Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys, with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. We've got a panel of experts ready to deal with a topic that we believe will matter and be educational and informational for you. Look forward to the next half hour and this opportunity to interact with them and also interact with you. The way that takes place is the information you see there at the bottom of your screen. Opportunities for you to interact with us. If you have questions, we'd love to hear them. Leading our conversation, he's the managing partner of Hollis Wright, Josh Wright. Josh, good to see you.
You too. Hope you had a great week.
I did
as
indeed.
Always.
Let me ask you a question.
Yes.
Hollis Wright makes available attorneys. Yeah. So right now, while we are on this show, you have attorneys from Hollis Wright that are standing by to speak with folks. Confidential conversation, all fair conversation. Why do you guys offer that?
Well, you know, it's our way to give back to the community, and it's been something that we've been proud to do since roughly 2000, around the 2009-10 timeframe. And we just like to be able to answer questions that are relevant to people's real world circumstances, right? So it's one thing to sit up here and talk about a legal related issue. Tonight we're going to be talking about Dram Shop, for example, but that will actually affect somebody in the viewing audience. And I like to know that we have lawyers that can help answer questions associated with topics that are relevant to someone's life. But if we can't help you, and it's not within the sweet spot of what we do, we're going to get you to somebody because we've got a network of lawyers that can answer some questions confidentially for individuals. And the last thing I'd say is this: a lot of people are intimidated to try and get access to a counsel and a lawyer. We've bridged that gap, I believe, because we offer the ability to get free legal advice, which I think only helps the viewing audience.
So again, those attorneys standing by all throughout the program tonight, just pick up the phone and give them a call. Our conversation tonight.
All right, so we're going to be talking about alcohol-related injuries. We hear a lot about drunk driving accidents where somebody caused a catastrophic event to a family, to an individual, and we're going to be talking about that tonight. But we're also going to work our way through this, that there are other alcohol-related injuries, whether it is at bars and restaurants, convenience stores, that have an impact on people's lives. And so we'll kind of work our way through that today. John Spade, who's been on our show a bunch, obviously one of our lawyers at our law firm, has really worked with me a lot over the years, because this is kind of one of the things I do. He's worked with me, and I hope I've given some wisdom to him in this area of the law, but he's become very accomplished in this area of law, handles these cases, and does a great job. So number one, glad to have you on as always. But this is kind of a unique area of the law that you've kind of taken an interest in.
It is, and I of course appreciate the opportunity to work with you and kind of under you on these types of cases, because it is kind of statutorily based, but there are a lot of nuances, and if you don't really practice in this area of the law a lot, can get you tripped up, and you can end up hurting your case. Even really early on, if you don't do some of the things and put some of the safeguards in place at the front end to protect your claim on the back end. So it's been great to learn it, and I'm really excited to talk with everybody tonight about this area.
David, the interesting thing about this area of the law, the area is called Dram Shop. That's just kind of a fancy word for alcohol-related injuries. But John's 100% correct, and it's one of the reasons that I got involved in this type of litigation way back in the early 2000 area, and that is because it is statutory. And you really have to know what you're doing. There are some certain tricks of the trade to be able to file these cases correctly. If you don't file them, you may completely waive certain claims that you had, or waive other related tort claims that you have that could impact you. So it's not a go it alone without a lawyer type litigation. And even if you are a lawyer, if you don't understand the nuances of the Dram Shop laws, you need to be very, very careful and make sure at least you're getting advice from somebody who knows this area of the law, because it can be complicated.
This is one of those topics that affect many people. We get some great questions. The question we have here: what is the law in Alabama about serving or providing alcohol to customers? So what's the law there say?
We mentioned that it's pretty statutorily based. You have the Civil Damages Act that really applied to selling, providing, furnishing alcohol to minors, and then you have the Dram Shop Act. And Dram Shop, it sounds like an old term. That's because it is. These statutes were enacted a long time ago, 1907. They've been on the books for a long time. And back in those days, a bar wasn't called a bar, it was called a dram shop. And a dram is actually a unit of measurements, 1/16, I believe, of an ounce. And so you have these two statutes that kind of work together, depending on who's injured, what the injuries are, and the circumstances of each case. Either one can apply, but those are kind of generally just the two statutes that will apply.
So let's unwrap those just a little bit, and we'll give you some real-world example of cases that John and I have handled in the past and that we currently handle. The Civil Damages Act claim, fancy word. The reality is, if a minor is served alcohol, okay? If a minor is served alcohol from a convenience store, from a restaurant, from a bar, even at a party, a social gathering, the parents of the minor or the guardian of that minor have a cause of action against the individual that provided or furnished or sold alcohol to that minor. And the theory, and really the policy behind that is, we don't want children that are under the age of 21 to be served alcohol for a number of reasons, the least of which is they don't make good decisions at that age, right? Yeah. Some of us know now at our age what alcohol can do to us and how to manage that when things, when you start to drink, you can manage a little bit better because you're more mature and have more wisdom. What alcohol is going to do to you. Well, younger folks just don't have that wisdom a lot of times. So we don't want to serve alcohol to minors. So the interesting thing about that claim, and we see it a lot, is a parent will call and say, my child was badly injured in an accident, but I've heard that we don't have a cause of action for him because he was the one that consumed alcohol. He was 19. And that's just not accurate. The reality is, under the Civil Damages Act claim, a parent has an absolute cause of action because somebody should have never served that minor alcohol in the first place, and that minor made a bad decision. And so ultimately, there is a cause of action there. And it's an interesting statute because really, in nature, it's a strict liability statute.
Yeah, absolutely. And, you know, kind of talking on what you were saying there about the parents having the claim under the Dram Shop Act as well. You know, sometimes somebody will go and drink too much at a bar, get in the car, and have even like a single vehicle accident and go cause an accident. And really only hurt themselves. And a lot of people will call in and say, look, I should not have been on the road. However, the bar shouldn't have continued to serve me while I was visibly intoxicated. Do I have any sort of recourse? The drunk driver, no. But there is kind of an ancillary claim for the spouse, for the child, just because of the wording of the statute, is anybody that's hurt in, or any person that's injured in, you know, person, property, or means of support. So that means of support claim can come in kind of like what Josh was saying with a parent, can come in for a wife, a spouse, a husband, or a child. So it's like we said, it's very nuanced, but you really need to work your way through it.
So, yeah, go ahead.
I'm just, on this subject matter, just a question we've got. What is the law that protects us if a drunk driver actually hits us?
Well, and we unwrap that a little bit. There's a statute called 6570, which is the Civil Damages Act claim. 6571, which is what we call the Dram Shop Act. That is what protects that type of individual. Mm-hmm. Then there's actually a claim under 6572 if you're injured through the wrongful conduct of a minor because the minor was sold alcohol. It's kind of complicated, but the short of it is, it's a 6571 claim, and that is what protects individuals. Let's take an example. If you and I are on the way to lunch today and somebody has too much to drink at a local bar or restaurant, and they have, you know, there's a car accident and they injure you and I, we have a cause of action under 6571, which is the Dram Shop Act, against the individual entity, bar, restaurant, convenience store that sold alcohol. And here's where that becomes interesting. A lot of times there are ways to prove visible intoxication, including forensics. And when you see blood alcohol concentrations, which with major accidents you're probably going to have, people get DUIs, they're blood alcohol tested, etc. And I know we can unwrap a lot of this after we come back from the break, but I'll say this. The forensics a lot of times will drive these cases. So, you know, you want to get a lawyer involved because in the scenario that I gave you, somebody's injured in an automobile accident from somebody that was served too much alcohol. You want to be able to establish your claim, and one of the ways to do that is a forensic claim. We can talk about some of the other ways when we come back that you can prove the claims and what you need to do immediately after one of these accidents to make sure you protect yourself legally.
Good deal. We're stepping aside our first break of the evening. As we do so, a reminder, take advantage of that opportunity to speak with attorneys from Hollis Wright Live, standing by right now to speak with you. Also, you can find the firm on Facebook as well as Twitter. Stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Talking about Dram Shop Law and alcohol-related legal matters and issues, a subject that always stirs up a great deal of feedback. We appreciate that. Welcome back into The Attorneys. If you have a question, something that pops into your mind, ways you can contact the show and contact the firm, you'll find that at the bottom of your screen. Josh?
So, when we went to break, we were talking a little bit about the forensics associated with these causes of action. And blood alcohol concentration levels is often one of the ways that you forensically can prove a cause of action. And that blood alcohol concentration, if you're involved in an automobile accident or a trucking accident where somebody had or was intoxicated, whether it's drugs or alcohol, those things are important. And getting lawyers involved early to be able to assess those causes of actions are important. And having the right experts in place to be able to establish the standard, which is what's called visible intoxication, are very important. And here's why, and John, you can kind of help here too. Explain in general terms why one has to prove visible intoxication in order to be successful in the Dram Shop Act claim itself.
Well, that's really where your liability stems from under the Act. The Dram Shop Act, the language of the statute says, furnishing, providing, selling alcohol in contravention to law. And what that kind of boils down to under the ABC regulations is selling alcohol to somebody who is visibly intoxicated. Josh mentioned BAC, blood alcohol content. That's one way that you can prove it. There are other ways that you can prove visible intoxication. Eyewitness testimony is always helpful. There have been even cases where, after we've gotten into the case and started taking depositions and talking to the bartender who actually sold the individual alcohol, who turned around and drove drunk, said, look, I think he was drunk when I gave him that extra shot or that extra beer. And, that helps. These people are trained and required to be trained, if they are bartenders, to be able to pick up on the signs for visible intoxication. So really, that is kind of your threshold that you're needing to prove, is that they were sold additional alcohol, that they consumed the alcohol while they were visibly intoxicated.
It's not enough, David, to just say somebody was drunk. You have to have been served alcohol at the time you were intoxicated and have shown or manifested symptoms that you were visibly intoxicated. And that's where the forensics come in. And John talked about several of those. Blood alcohol concentration above 0.15, which is 2 times the legal limit. Generally, experts will say in claims and causes of action, someone's incapable of hiding signs of visible intoxication at that stage, regardless of their threshold for alcohol, regardless of their age, regardless of their physical stature, what food they had, because there are certain signs that manifest themselves when you're at that level that a bartender who is trained and certified under the ABC regulations ought to be able to pick up on. Another, and I'll give you a good example of cases that John and I work on, and it's why you should get a lawyer involved early and quick. You want to protect the receipts, whether they are cash receipts, which have to be maintained by bars and restaurants, or credit card receipts before those are discarded. So it's why you want to get a lawyer involved, because a lot of times that is the forensic information that you need. We have a claim going right now where there's over $100 of alcohol in a 2-hour period to one individual. And I can just tell you, short of maybe a bottle of wine, $100 of alcohol involving shots and drinks, someone's going to be seriously intoxicated in that 2-hour period. So we were able to establish, because somebody got us involved very early on in the case, that amount of alcohol purchased by that individual was enough, because that person refused to do the breathalyzer. So it was the officer's word that they appeared intoxicated, and there was a field sobriety test, and they failed that. In addition, we were able to prove through the forensics of the receipts at the restaurant in that specific case that there's no question that they were intoxicated. And those are the things you got to do. That's why you get counsel involved, and get them involved early in these claims.
Getting some great feedback. Appreciate the feedback and the questions we get from you. A question we've got here: if the drunk driver who caused my accident was a teenager, can I still file a claim?
Yes. Yes, you can. And a lot of times, those claims are going to be under the Civil Damages Act as far as furnishing, like we mentioned earlier, it's strict liability, furnishing alcohol to a minor if they, knew that they were under the age and gave them alcohol. So you'll have the act or the cause of action that way. Sometimes if it's at a house, it might be against a homeowner's policy, or, of course, if they go to a bar or a private club and are given alcohol, then you have the claim there as well.
Yeah, and we see this a lot. And if a third party minor injures somebody, there is a specific statute that protects those types of claims. And it is a little nuanced, but it's important to recognize that it's conceivable in that case, if you can even believe this, that the person that caused the accident that's a minor, his parents may have a cause of action that's a strict liability violation of the Dram Shop Act for serving that minor. And the injured third party that was injured by that minor also may have a cause of action against the restaurant or bar. So a lot of times what happens is there are a lot of different claims involved and a lot of different parties involved in these. I know we're getting ready to go to break. One of the things I want to talk about, super important, is the interplay in these claims that John and I see all the time between the criminal side, somebody's being prosecuted for criminal conduct for causing a terrible accident, and the civil side, and how those two things meld together, because a lot of times that's what we're doing, and we may even be sitting for a long period of time while the criminal side has stayed pending resolution of the criminal case before we can even get moving. I want to talk about that when we come back.
All right, we'll pick that up whenever we return. As we head to break, this is our final break of the evening, so if you have a question or would love to speak with an attorney from Hollis Wright live, you got a few minutes to do so, so take advantage of that. Stay tuned, more of the attorneys coming right up.
I'm Carter Clay with the law firm of Hollis Wright. When you serve on a jury, you might expect to have all of the evidence presented to you during the course of a case. But there are some forms of evidence that are not allowed in court. In tonight's Legal 411, we are answering the question, why can't jurors see police incident reports? Most jurors would like to see crash reports during a trial, especially since these documents almost always show the investigating officer's opinion on who was at fault for the crash. Unfortunately, Alabama law prohibits the introduction of such reports into evidence. Alabama law states that no such accident report shall be used as evidence in any trial, civil or criminal, arising out of an accident. According to lawmakers who wrote and approved this rule, the reason accident reports cannot be admitted as evidence is that a jury might place too much weight on an official document such as a police report. There are some exceptions to this rule, of course, but most courts generally won't allow this type of evidence to be shown to a jury. Despite this rule, police officers who investigate crashes are still allowed to testify. They can tell a jury what they saw at the scene of the crash, including the road conditions and the positions of automobiles. An officer can also inform a jury of most any statement the people involved in the crash may have said to the officer during the investigation. The accident report can even be used to refresh an officer's memory of the crash. But the actual document itself cannot be introduced into evidence, and the officer's opinion of who is at fault is also excluded. That's because the jury is charged with deciding fault based on all the facts presented. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will always respond to every question you send in. That's our pledge and promise to you.
Welcome back into the attorneys. This is our final segment. So if you've been pondering, thinking about making a call, reaching out to the attorneys of Hollis Wright, you got just a few minutes left for you to do so. So take advantage of that. Jumping right back into our conversation, a question we've got here. If I was injured, or I was injured by a drunk driver, but the driver is going to jail, so how can I recover damages to pay my medical bills?
Well, as far as the drunk driver is concerned, you can prosecute both civil and criminal at the same time. The way it actually works out in real practice, though, a lot of times the civil action will be stayed while the criminal works itself out, just because of Fifth Amendment protections. They don't want to go and testify in a civil case when they have their criminal going on. But there's other things you can do while it's stayed. If you aren't, if you aren't pursuing something against the bar, even if you are pursuing something against the bar, what you can do is go ahead and get the insurance companies on notice. Go ahead and file the lawsuit. That way, when the criminal matter wraps up, you're ready to hit the ground running on the civil side of it, even if you aren't able to, answer interrogatories or take depositions, that sort of stuff. And a lot of times, the criminal matter can be used to kind of prove out the fact that he or she was drunk when the accident occurred. So there can be advantages to kind of waiting a little bit on the criminal to wrap up, but it doesn't mean that you completely stop all civil while you're waiting the criminal, but both can go on at the same time.
And that sometimes will frustrate clients, and we see that a lot, which is, why are we not moving forward? Well, it's because the judge has stayed this civil case, and sometimes we can request to set aside the stay for limited purpose of going against the restaurant, the bar, the convenience store. And sometimes the judges will allow that, sometimes they won't. But sometimes the client will get frustrated. And what we have to explain to the client is it is advantageous for you to have the intoxicated party that caused the accident in the case itself. And we don't want to get too into the weeds here, into too many nuances, but Alabama is what's called a joint and several state, which means that those individuals that contributed to an injury can jointly be held responsible. And so you can have a bar, restaurant, convenience store over here and a drunk driver over here, and we can hold them both responsible. But we don't apportion damages. So for example, we don't say the drunk driver was 99% responsible and the bar was 1% responsible. If you show that any one of those parties was at all responsible, 0.1% responsible, you can collect the entire amount against whoever has the insurance to be able to present it, or whoever has the resources. So a lot of times we'll keep the drunk driver in there because a jury is likely to send that guy to the moon, if you will, for the wrongful conduct, and we can collect that amount directly against the convenience store, the bar that did the wrongful conduct. So a lot of times there are some legal related issues that we use to the benefit of the client, and it requires us to keep that drunk driver in the lawsuit, even though it's going to slow that down. Talk for a minute, John, if we can, because I know we get questions about this a lot. How does insurance work? Like the individual convenience stores, bars, restaurants, do they have to carry insurance? And if so, what do those look like?
Yeah, they are required by the state to carry insurance. It's relatively low in comparison to the enormity of the damages that are usually in these types of cases. It's $100,000 in coverage. But what we find most times is they have what's called a commercial general liability policy, or CGL policy, that will offer available coverages over and above that, usually $1 million in coverage, but they're required by the state to have $100,000. And then of course, You could also go after the drunk driver's insurance. They're required by the state of Alabama to have a minimum of $25,000 per person, $50,000 per accident. And then if you have uninsured, underinsured motorist coverage over and above that, you can then access that as well. But the bars, restaurants, they're required to have 100,000. A lot of times they have more.
So, we talked earlier about, don't go it alone. What John just mentioned is you want to be able to have counsel involved, whether it's us or someone else. We totally get the fact there are some other great Dram Shop lawyers out there in the state. But you need to be with somebody, and the reason is because you want to make sure that you identify all the potential ways that someone can recover. Because, the sad part is most of these automobile accidents and these Dram Shop related claims, they don't involve simple injuries, they involve catastrophic injuries where somebody did nothing wrong except be in the wrong place at the wrong time. You want to make sure you've got counsel to be able to make sure that you protect that individual completely.
We've got less than 3 minutes remaining, but I want to get to one more question if we can fit it in. If someone that caused the injury is charged and convicted of a DUI, does that help a Dram Shop case?
Absolutely. If not for the reason that Josh mentioned earlier, it helps to keep the drunk driver in the case, and if they are convicted for a DUI, but it also really helps lock down the fact that they were under the influence. If they are convicted of a DUI, it helps lock down that testimony that they were under the influence when the incident occurred, and then also the joint and several liability that we talked about, joint tortfeasors, and keeping that drunk driver in the case.
Yeah, there are generally, when you are convicted or you plea, generally when you plead, there's going to be a transcript where somebody is responsible for pleading to the conduct charged.
Right.
Even if there's a lesser offense that has been negotiated with your criminal defense lawyer, generally they're still pleading to some alcohol-related event that can significantly help the individual Dram Shop claim.
Time just flies by whenever we're on the show, but about a minute and a half remaining, but want to get a final thought from the both of you. And John, if you would, you go first, please.
Absolutely. We talked briefly about how, drastic these consequences can be when people get behind the wheel and they're intoxicated. A lot of times these can be prevented by either calling a taxi, Uber, Lyft, calling a friend, calling your parents. There's a number of things that can be done to prevent these accidents, and we really hope that people will make the smart decisions and choose those alternatives.
We've gotten to the point, David, where we know enough about the Dram Shop world and we do enough of these cases that we are retained at times by facilities to help and assist them in training their employees to do it the right way. There are a lot of bars and restaurants and convenience stores that do it 100% the right way because they train their employees to do it. We're here today to talk about those claims where somebody's not doing it the right way. They didn't do it the right way. They did not stop serving somebody and somebody was injured, and we're here to help if that happens.
Appreciate the time. Covered a lot of ground. Thanks to both of you for being here, and thank you for joining us as well as we wrap things up. Here's how you can get in touch with the firm. Also find them on social media as well. Thanks so much for being with us. We'll see you next time here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.